I think a few more people will be joining us. We are expecting about 600 people on this webcast, so quite a few folks. Just a couple of notes. First of all, my name is Lynn Beauregard. I am the president of Governance Professionals of Canada. We are a member-based organization that promotes and supports the role of governance professionals and all of those who work in the trenches of governance across Canadian organizations. Our mission is to provide resources, education, news, and to track key trends and challenges in governance. We provide valuable information on recent changes and developments that affect everyone vis-a-vis governance, their boards, and governance practices. So this is what we're trying to do here in this age of COVID is to try and address a lot of the unexpected and unprecedented situations that many of you are finding yourselves in. For those of you who might have missed it, we held a similar webcast on Friday, this past Friday, on governance, risk implications, and the role of the board during COVID-19. This webcast is now available on our online learning page on our website, which is gpcanada.org. So we're very pleased to bring you today's seminar on moving to virtual AGMs in the age of COVID-19. We've had many inquiries since this is all hit. This is AGM season, so many of you are already asking these questions and looking to answers. So we felt that it was would be useful to assemble a panel to discuss this and to go over some of the key issues and key questions that you probably have. Just a quick note as well, you're all muted on this webcast except for the panelists that you can see on your screen. And if you have any questions, we will try and get to them. We have an hour, and I know there are a lot of speaking notes that we have prepared. But if our moderator finds it to be relevant and we have time, we will try and get to those questions. Just please make sure that they are put onto the chat box, which you'll see on the bottom of your screens. So again, I would like to now turn to the session and addressing the issues on virtual AGMs, legal implications, statutes, notice and disclosure to stakeholders, available technology solutions and platforms, the logistics of holding virtual AGMs, participation from shareholders, and best practices and in general, what are the implications here. So I'd like to welcome our moderator, Charlotte Conlin, who is counsel with McMillian, and our panelists, Lara Donaldson, who is Chief Operating Officer for TMX Trust, Christopher Main, who is Associate General Counsel and Assistant Corporate Secretary for TELUS, and Nick Santini, Assistant Corporate Secretary for TMX Group. Unfortunately, Emily McHugh was called away on an urgent matter and could not be with us today. So this is our panel, and I'd like to now hand it over to Charlotte to start the discussion.
Thank you very much, Lynn. And I'm very pleased to be with you all today and moderating this panel. And I just want to give a tip of the hat to the Government Professionals of Canada for putting this panel together so very quickly. Certainly the timing of the current public health crisis with COVID-19 coinciding with AGM season has put a lot of pressure on corporate secretaries and on boards, figuring out how to manage holding an AGM. Nobody wants to be offside, and everyone wants to do the right thing, which often is putting us in a very difficult position in figuring out what to do. Our panelists today have a wealth of experience, some of it very recent. It's unfortunate that Emily McHugh isn't able to join us, but I can actually step in and speak for her on some of the experience because I worked with her and Farm Mutual Reinsurance Plan in getting a court order last week to allow them to hold their AGM virtually. So what I propose to do is sort of have two parts to our discussion today. The first one is really going to focus on the governance perspective and the corporate compliance issues and whether or not you can, without anything else happening, decided to hold your AGM virtually rather than hold it in person. Not every corporation is going to be able to do that, and that could be a function of a couple of things. It could be a function of the governing statute that doesn't make it easy to accommodate, doesn't easily accommodate a virtual general meeting or virtual shareholders meeting, or in our case with Emily, a members meeting of a non-share capital corporation. once you have concluded that you are in a position, from a governance perspective, to hold a virtual AGM, then it's how do you actually hold it and the logistics of it. So I'm going to start off with just, it shouldn't be taken as legal advice, of course. Everybody needs to look at their own statute and reach out to your external counsel if there are any questions. But the first question really is whether you can. And there can be different answers based on what statute your corporation is governed under. For example, permissive. So long as there's nothing to the contrary in your articles or your bylaws, OBCA is going to let you have an electronically held meeting, and it's going to deem that your shareholders who vote electronically or who establish a communication link with your meeting will be present for the purposes of quorum. A CBCA, in contrast, is a little bit different. You can have an electronic meeting, but there are additional requirements that may impose technological constraints or require you to go an extra step in finding a service provider, in that your shareholders are going to be deemed present only if they're able to communicate adequately, is what the statute says, with each other. The BC Business Corporations Act similarly requires shareholders to communicate with each other. So once you have a requirement that shareholders communicate with each other, you are going to need to then figure out how are you going to find a provider who's going to allow you to do that, and then you need to decide how you're going to actually manage that at the meeting itself. Other statutes are very permissive, but this next step of your analysis is going to be to take a look at your bylaws, because where a statute may be permissive and whether you can hold your AGM virtually, your bylaws may have handcuffed you, and then you're looking at what do you do? I mean, some statutes will let the board of directors amend the bylaws and put it to the meeting of shareholders. Or you may need to decide that there isn't time for that, or you don't want to take that approach, and you may be looking at a court order. One thing virtually every corporate statute does allow for is the court to step in where it is impracticable for the corporation to hold a meeting in the way required in the statute or the bylaws. The problem we have is most of the courts are not shut down, but are only hearing matters on an emergency basis, which was the position that Farm Mutual Reinsurance Plan found itself in. I think courts, I'm going to speak briefly in sort of my take of what's happening in Toronto on the commercial list. The courts understand that corporations may not be dealing with urgencies the same way that happen in family law matters or in criminal matters or provincial offense matters, but they understand that corporations are at the beginning of the season, and that they understand that we need to have a workaround to avoid a situation where a corporation is not going to be able to hold an annual meeting because of the public health directives, and quite frankly, just the responsibility that, and questions that every board has probably struggled with getting to this point of how do we be good corporate citizens? How do we comply? We don't want to put our shareholders at risk. We don't want to put the public at risk. So a court order may be your last, sort of your last step, and I think it is an option that may be open, but you do need to reach out to your external counsel and leave them some time to maneuver to get you a judge and get you a hearing. So Christopher, TELUS grabbed a few headlines a couple of weeks ago because you had reached the conclusion that you did need to get a court order to allow you to hold your AGM. Can you give us a little bit of insight about what your particular challenges were at TELUS? What led you to that decision?
Sure. We've actually been looking at different formats for our AGM for some time now. Our CEO has been a bit impatient in saying that we as a company, as a telecommunications company, can arrange for people to meet their doctor over their phone, but not to attend their shareholder meeting. So we've had some pressure that way to look at some different options. And as we were beginning sort of our emergency preparedness plans and finalizing our circular right around the same time this year, a few million years ago, but just a couple weeks ago, we realized that we needed to look into this. And so we looked at what the restrictions were. The main sticking point for us in our statute was, and it's a little bit different than the statutes in some of the other provinces, was an actual specific requirement that the meeting be held at a location. Obviously a virtual meeting does not have a specific location, unlike, let's say, a hybrid meeting. which would have a location as well as online participation. And we needed to be ready to have a fully virtual meeting. So with that, we thought the best thing to do would be to contact our external counsel, just as you were saying. They got us into the court on an urgent basis, and we were able to get an order deeming the virtual meeting to take place at a location in Vancouver at our head office.
How receptive was the court to the application?
Very receptive. Obviously, as I said, it was almost a different time. The government had just started warning against groups of more than 250 people getting together, which seems like an enormous number of people now. But that was the type of thing that we did present to the court. And the court was very interested in the technology that we would be using. Again, very, very helpful, but in going through his duties under the Act, we wanted to make sure that was very interested in the technology generally. And we did present the technology we would be using. And that's understandable given the statutory requirement that you mentioned.
What has been shareholder feedback on this? What sort of outreach did you make to shareholders? I mean, had you issued your notice yet, or?
We had issued just our notice to beneficial holders, our CDR filing, but we haven't actually put out our notice and circular. Reaction at this time and in this context has been, I mean, this is basically the only way that we are able to go forward. So it's been very positive, if any at all.
I'm going to step in now. This would be the point where I would have started asking Emily some questions. Farm Mutual Re is, and I think you probably have some members as well who are not business corporations, but are non-share capital corporations or associations. In this case, we were under the Corporations Act, and our problem was, while the Corporations Act permissively allows non-share capital corporations to hold electronic meetings, there is a specific statutory exemption or exclusion for insurance companies under Part 5 of the Corporations Act. So the tools were there, but we were told we couldn't use them. So we concluded, and there's also a statutory requirement that the election of directors happen at a meeting of members in person. So we had two reasons why it was just simply, we were not able to do this without some intervention. One thing that Farm Mutual Re has is a very close relationship with its regulator. And that relationship helped them tremendously. One option was to reach out to the ministry to see if we could get an emergency amendment to the Act, which I thought was quite an audacious but possible thing, since they are possibly one of the very few insurance companies or non-share capital corporations that would have been affected by this. It would have been a fairly targeted amendment. That wasn't going to happen. So getting the involvement of the financial services at FSRA was vitally important. And they were able to actually get word to the commercial list that we needed help and we needed a court to hear us. We had prepared our materials. We were ready to go on, I guess it was Friday, a week ago, last Friday. We were ready to go. We had our hearing date for last Wednesday, but on the weekend, the court announced its shutdown. We were, as I said, the commercial courts are aware that people are out there, and corporations have different senses of different urgencies, but holding an annual meeting is a vital and fundamental part of compliance and governance. So we were able to get in front of Justice Haney, who agreed to hear us by teleconference. And it's interesting that your judge in BC was worried about or asked questions about the technology. How would you do it? The only question we had was how our members felt about it. And I think that's sort of to the question of stakeholder engagement. Farm Mutual Re had reached out to its members, its voting members, on the Friday as we were preparing our court materials, and said, this is what we intend to do, and invited members to get back to them if they had any concerns. And there was, we had heard absolutely nothing. And that answer was good enough for Justice Haney. to issue the order that we needed, which was basically to allow us to hold the meeting, and a couple of logistical workarounds in the difficulty in getting in Ontario an order issued and entered. So we were able to do that. The court office is open for that. But had they not been able to, the order was as effective as if it had been issued and entered. So there's like little logistical things that external counsel and your litigation counsel may need to advise on, but that's sort of where we were. We found the court was very accommodating, and the regulators was incredibly understanding. I think we're not the only insurance company that was facing these problems, but certainly the workarounds are there. I'm going to take just a quick moment to take a look at some of the questions here. I think we've got a lot of people with similar questions. So comments that, for example, that the registrars and the co-op acts in Manitoba, Saskatchewan, and Alberta have all waived compliance for their annual meetings. And I note that in Ontario, the Ministry of Education had issued a regulation that allows school boards to hold their meetings virtually, which is interesting. I know that probably most people are aware, certainly if you're a public company, the CSA issued guidance on Friday as well on how to move to a virtual meeting. So, Nick, I'm going to turn to you and ask if you've got any thoughts on the getting to the point where you can hold an AGM. My understanding is that TMX Group has held virtual meetings in the past.
Yes, that TMX is an OBCA company, and our conceding documents allow us to hold virtual meetings. So for the past 2 years, we actually conducted our annual and special shareholder meeting using a hybrid method. That's both in-person and by virtual.
So you didn't need to do anything except for reach out to your shareholders and let them know that this was the plan for this year. Are you holding a hybrid meeting? Like, it seems to me that that's probably, I've read from some of my colleagues saying that some corporations who are holding hybrid meetings are going to hold them with proxy holders, but might not allow shareholders to actually attend and require them to attend virtually. Do you have any thoughts on that?
That's an interesting concept. We haven't decided at this point what we're going to do for our meeting. Our board is meeting later this week to approve the circular. I think management is recommending a fully virtual meeting. That way people don't have to come into a meeting room to attend in person.
Chris and Nick, what level of board engagement did you have throughout this process? I'm assuming the board has been fairly active in being involved in this decision. Look at you first, Nick. You're not muted.
I'm not muted. So going back 2 years, this is obviously a new concept. In Canada, there are very few companies that have gone either hybrid or fully virtual. It was an opportunity that our board felt to give shareholders that weren't in the Toronto or GTA area an opportunity where they can actually connect to the meeting virtually. They can ask questions, they could vote. So they're really taking part in the meeting as though they were there.
And I would say we were actually having a regularly scheduled conference call meeting of our board on the day that our external counsel was going to court to request the order. So we were keeping our board not only involved and participating in that decision, but we were giving them updates real time when we had received the order.
So I guess one of the problems people are having right now is figuring out how to hold it. There are a couple of virtual providers, Broadridge and Lumi. Nick and Lara, I'm going to bring you into this a little bit as well. What has your experience been, or thoughts in engaging service providers? Are they up to the task, do you think? And Chris, I'm going to, certainly you should jump in on this as well, because you're in the process of organizing this.
From a TMX perspective, it's really a collaborative approach. And we have our corporate secretary department, the internal communications department, our transfer agent, and Lumi. And we really rely on our transfer agent, which is TSX Trust, to sort of manage that relationship with Lumi to make sure that everything that needs to happen before our meeting is all set up so that when we walk into our hybrid meeting, there wasn't any concerns on our part or management's part that there was going to be no issues with having the hybrid portion of the meeting.
How about you, Christopher? How was your experience with getting the service provider lined up? You know, I know that I am going to be attending a dress rehearsal tomorrow for our meeting. Any thoughts on the logistics? How easy has it been?
It's been a team effort, and it certainly involved our transfer agent. We are working with Lumi as well, and it's involved our team that takes care of the audiovisual portion of the meeting. So we've been, again, on conference calls, on online demos, basically running through, just as you're about to, running through the logistics, making sure all of the links and things like that work. But knock on wood, relatively smooth so far.
One thing we haven't talked about, you know, some annual meetings are relatively straightforward things. You present the auditor's report, you elect directors, there may be some other business. Other annual meetings may not necessarily be so dull, particularly if there are any matters in which where we've got a proxy contest. Has anybody thought about how we're going to manage that? And I guess maybe we could start off with maybe an easier question, because I think that's almost like asking how deep is a hole, how are you going to manage a proxy contest? Lara, do you have any insight as to how proxy advisory firms are giving, what their view is about annual meetings or virtual ones?
Sure. So ISS has not put out any recommendations on either virtual or hybrid meetings in Canada. Glass Lewis has had recommendations for the last couple of years, and their concern really is about how shareholders can communicate with each other. And they are looking for what they call robust disclosure in connection with how the meeting will be run. They have advised that for this year, because of COVID-19, they're being a little more flexible. And they will be looking for disclosure about why an issuer has chosen to move to a virtual only meeting, but then we'll be moving back to their previous recommendations for any meeting held after June 30th of 2020. Sorry, Charlotte.
I was on. Sorry, I was on. I'm trying to like. There've been a lot of comments about background noise. Has Glass Lewis said anything? Or
so that was Glass Lewis.
Oh, sorry. Yes. Yeah, okay. And I guess some of the other questions. We've got some really good, very technical questions about. And I guess again, anyone who's in the process of engaging a service provider might be able to answer these logistical questions, like. How are you going to manage voting, registration, and participation? What about public attendance? Will the public be able to log on? And how are we going to manage quorum? I think quorum is going to depend a little bit on what the governing statute says about whether shareholders, how they are going to be considered present at a meeting. Do you understand it? And scrutineers, like, how are these details going to be managed?
So virtual meetings have been around for a number of years. There has not been a great deal of take-up in Canada, but in the US there has been hundreds of meetings, starting as far back as 2001. So the standard process for a virtual meeting for a typical meeting is very effective. The scrutineer is still involved. They still provide the proxy numbers. And what the virtual meeting really does is provide a registered shareholder with a login that allows them to access the meeting through either an app on their phone or through a website. And with that unique login, they are identified and allowed to vote. So that's how we make sure that it really is a shareholder who is voting, and we provide that security that it is someone who properly has the right to vote. One of the issues that has been faced in Canada is the third-party appointment process, because a shareholder, a beneficial shareholder, or a registered shareholder can appoint a third party to attend in person. There's been logistical issues with how that third party gets the necessary information to allow them to log in to vote and gets matched with their appointee. But the transfer agents have come up with various different mechanisms to work through that process to ensure that that third party does have the right to vote. Shareholders, someone who's a guest can then log in to view the meeting and typically ask questions as well. So there is a very robust and standard process for virtual meetings. One of the things that really hasn't been contemplated is the idea of a proxy fight through a virtual meeting. Contentious meetings are very paper-based. It wasn't too long ago that even e-voting got shut down if there was going to be a contentious meeting or a proxy fight taking place. And to my knowledge, there's never been a proxy fight actually held via a virtual meeting. And there's been a number of articles that have come out from law firms over the last little while in connection with virtual meetings. And every single one of them that I have read has said that a virtual meeting really shouldn't be considered in a contentious situation. That doesn't mean we're not going to be faced with that issue this coming year, given the unique circumstances that we're all in, but it's not something that's really been considered at this point.
One question that I've seen come up a couple of times is, so far, there's Broadridge, there's Lumi. There really isn't a whole raft of other service providers out there, and some companies are smaller, and it shouldn't be taken as giving anybody legal advice or a go-ahead on here. Go ahead, but how does everybody feel about, like, what if you are left with only being able to do a teleconference or use something like Zoom? What would be your concerns about using something like that as opposed to something like Lumi, which is a platform that's designed to register shareholders, designed to tabulate the votes and assist in the scrutineer function?
So the concern with a webinar only type of meeting situation would be allowing shareholders to vote. And I would have concerns that, there could be an argument that shareholders' rights are being infringed upon because they wouldn't be able to be validated and actually vote at the meeting. There may be workarounds for that. I do know that with only Lumi and Broadridge really being the two service providers for virtual meetings in Canada, there has been consideration given as to possibly other ways that voting could be done. And I do know that, for instance, TSX Trust is looking at working with Lumi to allow us to access their platform to run the meeting without requiring the Lumi staff to be there, which is really where some of the problems have been in terms of meetings being booked up or certain days not being available.
Not going to ask anyone to divulge what they're spending, but this is undoubtedly going to be an additional cost for many corporations. Are we talking about, low-end 5 figures? Is this going to be how significant a cost would you consider it to be? No one needs to tell me what they're actually paying, because I suspect that the fees being quoted may be varying dependent on how big the corporation is, how many people would be attending, the amount of support that you're going to need. If you're a smaller company, what if your choice is between spending money that you really feel like you need to be conserving right now? Liquidity is about to become a problem for many, many corporations, and simply saying, we're not going to have the meeting, let's see what happens. Any thoughts on that? Again, this is not a go-ahead for anybody to make that decision. You must consult with your external counsel. Any thoughts on the dispensability or indispensability of the annual meeting, given it is a statutory requirement? Absolute silence. No one wants to take that question on.
So, I can speak a little bit about the cost. There are variables to the cost, and there's different levels of the virtual meeting that are provided. So a lot of the meetings that have taken place in the US are audio only. So they're not actually doing the full live slides and live video stream, which is obviously more expensive. So there are less expensive options available. But you also have to balance it against other cost savings that you're looking at, such as the venue, the bookings, the catering, the travel, and other things that you would typically be spending for a full meeting with a location.
So different costs, but still a cost.
Correct.
How about one question I had was the decision, I mean, I'm assuming that this probably the answer is yes, but the decision to move from an in-person AGM to a all virtual AGM, strikes me as this is a board level decision. Would anyone disagree with that?
In this context, I mean, I think your board would of course have to be informed and be involved in the decision, yes. But in the context we're in right now, there aren't a lot of other choices to have your meeting. So you're almost getting to the point where you're asking your board, are we going to hold this meeting or not? Are we going to have to delay the meeting? What are the consequences that way? So I don't know if it's specifically, are we going to have a virtual meeting? It's almost a bigger question. And once it's a bigger question, I would agree it does go to the board.
Another question that's popped up a little bit is people quite rightly pointing out that most votes, especially in widely held corporations, are going to be present at the AGM through a proxy holder. Does this make the possibility of a hybrid meeting more palatable if you could, if you have a fairly small number of people? Would that be a consideration to make, or do you think really it's this season it's virtual or postponed?
I think we're really stuck at the spot right now. If you're going to hold your annual meeting, it has to be virtual. Every day seems to be a new day with new changes and new requirements, and I don't think it's possible to host a meeting even with a small group of people in attendance would be permissible by any of the provinces.
I guess another question is, I've mentioned that there have been some regulations passed dealing with different types of meetings in light of I think every province has now declared a state of emergency. I guess one other option would be to look to somebody like Industry Canada and whether or not they would grant blanket exemptions. I know the CSA has clarified, and made things much easier for reporting issuers to change their meeting to a virtual meeting, even if their materials have already gone out. I think the concern simply being shareholders know what's going on and still have an ability to attend and participate at the annual meeting. Any other creative ideas that perhaps could be picked up and carried on by others who have contacts within, for example, Industry Canada or other regulators, on what might make life easier for corporations to get through this problem? We have a bottleneck, we have a problem, and we now have a bottleneck to the solution. If you could wave your regulator's pen, what would you say? Chris, you're smiling a little bit. I'm going to pick on you.
I'm smiling because I'm happy that we didn't have to get to that point. We did find that the obstacle that we had could be addressed by going to the court, and that's something that I'm happy that the chips fell where they did, and that the time allowed us to do that. I think what we're sort of leading to is what happens then if you do decide to go ahead and there's a question about the validity of your meeting. You start to look into, of course, you're starting to talk to your external counsel, as you're saying, Charlotte, but you start to look into questions of holding over what is actually what's on the agenda as the election of directors, appointment of auditors, any other special business. What if there's a question about the validity of this meeting that we're holding? You have to start preparing that way.
Yeah, you would kind of hope that under the circumstances, shareholders would be somewhat understanding, but I have been in enough proxy fights to know that if you have if you were heading into this AGM with a proxy fight, if you have got an activist shareholder who is unhappy with things, the direction and decisions the board is making, it seems to me that there is the risk there's a risk period. I mean, one thing that my view is that boards have to make decisions. They have to make it, the company, each corporation's got to make a decision with the AGM. You can't not do anything, otherwise you're not going to have an AGM. And simply defaulting and not making a decision, I think, is worse than making a decision and having it be the wrong one. Are there any concerns about, I think this only applies to larger companies, any concerns about this being taken advantage of, or do you think we're all going to be a little more grown up than that? Unfair question. I think other participants are able to see this. I saw somebody mention that there is an additional service provider in Canada called Avenue 4. I don't know anything about them, but I will leave it to people to take that name away and see what they might be able to do for you. I think one of the problems is that there's no easy, like some of these solutions are not one size fits all. There have been a few questions about the Canada Not-for-Profit Corporations Act. It looks like somebody has actually looked up the answer to that. Has anybody got any current or insight from, somebody had noticed that or commented that the TSX has issued guidance today. Has anybody seen that, able to speak to that? I haven't had a chance to take a look at it. Okay, I think the point is that regulators and TSX, the CSA, they're all aware of the problems that we're under. So I think it's also important to keep a constant eye on updating. And I know that law firms are, everybody's putting out a bulletin. My firm put out a bulletin. I think Oslers and Tories have also put out a bulletin. I think reaching external counsel is probably a very good idea, especially if you anticipate needing a court order or having a tough time sorting through which is the best of a bunch of not great choices. Are there any other worries about holding a virtual meeting? We've talked about a lot of potential pitfalls. Anything else?
I think I would address one, which is the concern that, and it's certainly a concern that the proxy advisory firms have had, which is that somehow a virtual meeting will limit communications that shareholders can have with management and the board. And that's something that obviously we would take very seriously. But I think it's a little bit, and again, my own view here, but a little bit quaint, the idea that the only time that shareholders can speak to management and the board or each other is at the annual meeting, at some sort of a formal meeting where they come to a mic. I think that's no longer really the case. We have a lot of outreach to our shareholders, and our shareholders are not shy about providing their thoughts to us as well. So I would say that the one time a year is a little bit like a one time a year employee evaluation. It's not really the case anymore, and that I think is worth keeping in mind as we're thinking about this.
Chris, the idea of shareholder engagement. How is your meeting going to allow for, or is there even be able to encourage shareholder participation in the meeting?
Actually, I mean, it's not going to be that different than any other meeting where you have an opportunity at each motion for shareholders to ask a question, to receive answers from the chair or basically from the chair or anybody else who happens to be there to more appropriately answer the question. But we would expect that it go through exactly the same way as it usually would, except it will be done on a chat. a little bit like this meeting.
Right. And I assume that shareholder, I mean, I agree. It seems to me that if you've got the facility, you got the technological platform to allow shareholder feedback, that you could even deal with things like shareholder proposals the way you would at an annual meeting in person. Like, there, it seems to me that the meeting is almost more of a concept now as opposed to an actual physical gathering in a place. It's the opportunity for the shareholders to come and hear from management and to exercise their right to elect directors and make proposals and everything that we've always done.
Agree with that.
Nick, have you got anything, anything that you've thought about or planned ahead? Any insight you've done hybrid meetings before? Any insight or sort of, gee, I wish I'd known before kind of thoughts on for anybody who's stepping forward and doing this for the first time?
I think for a virtual meeting, it's a little bit different than our hybrid meeting. We're going to expand our disclosure really to help our shareholders who this will be sort of a first time for them. So really what we've looked at, because there's so few companies in Canada that have done a fully virtual meeting, there's not a lot of examples of disclosure out there. We're really going to look at what the Glass Lewis policy is and what their suggested effective disclosure is. And we're going to incorporate a one-pager in our circular that will have a sort of a Q&A, which will talk about how to connect, how to ask questions. If questions are made throughout the shareholder meeting that aren't answered, where they can look to on our website for responses by management. If they're unable to connect or if they happen to lose their control number, who to contact. So a lot of Q&A around that, which will hopefully help our shareholders all be able to connect to our meeting.
In terms of a question that's come up a couple of times as well is voting. Is the software going to track the identity of the shareholder because they've registered? Is voting going to be anonymous? Is any thought been given to that? And have been any concerns raised by shareholders about the anonymity of voting?
So the way the virtual meetings work now, voting is not anonymous. Shareholders receive a unique ID and they log in, so the scrutineer and the issuer know who's in attendance and who's voting. That doesn't mean that other shareholders know how other shareholders are voting, but the scrutineer still needs to know how people are voting and who they are so they can appropriately track each motion as they go through the meeting agenda. So anonymous voting is not an option for virtual meetings, and it wouldn't be for an in-person meeting either.
Right. Has anybody thought about, and this may depend a little bit again on the nature of the corporation, some shareholders, often the ones who show up at the AGM, are often older and may not have either the technology or the sort of the ability to use or the understanding of how to use the technology. Has anybody given thoughts about the potential disenfranchisement or how you would accommodate or what could be done for shareholders who can't attend or use a virtual annual general meeting?
We were actually most concerned about some of our retiree shareholders who do sometimes attend in person at our meetings, because we were most concerned about older people in the COVID-19 situation. Though they were the people that we were most worried would show up regardless. And we wanted to provide an alternative. I guess we're lucky to have some fairly technologically sophisticated retirees and shareholders among our shareholder base, just given the nature of our company. So we're just trying to make the technology as easy to use as possible.
I'm just looking at some of the other questions. I've got one, I guess, there may be other concerns about accessibility as well. I mean, the ability to use these platforms may not necessarily be as easy for people who have limitations, physical limitations, as well as economic. I would assume that most people probably, aside from being senior citizens, will have access to the technology. Anybody give any thought to providing closed captioning or anything else to enhance accessibility of the meeting?
I know we'll be providing translation. I don't believe we've contemplated closed captioning. It's an audio-only meeting in our case, but it will be audio-only with slides, with a slide presentation. We have not considered closed captioning.
That may be a tweak down the road, I think.
Yeah, interesting thoughts.
This is a big bite right now to just simply move from the way we've always done things to a virtual AGM. I'm sorry, I'm pausing here simply to take a look and see if there's any other. There's a lot of questions. We're not going to get to all of them. We will try to respond to questions. I think I just want to point out that if you need legal advice on how to interpret your governing statute or what you do with your bylaws, you should be reaching out to counsel. A lot of the questions here are fairly technical. Let's see what else we've got here. We've talked a bit about the pitfalls. Somebody is asking us to crystal ball gaze AGM schedule for July. I think no one can actually. That's a tough one. Like, should you be planning to go to a virtual meeting? I think that if you're looking out in July or second, third quarter for your AGMs, you may have better luck booking a service provider. Whether you need to go to the virtual meeting, I don't know. I don't think anyone can answer that question yet. Another question, again, back to shareholder engagement is, and somebody's pointed out there's no such, if there's concerns, shareholders can always appoint a proxy. So even if there's concerns about whether or not they can attend the AGM, they could appoint a proxy who could do it for them using the virtual facilities. Shareholder engagement as well. Has anybody taken any steps to prepare the board for how they may deal with questions? They're going to happen without people standing up at a microphone. They're going to possibly sort of seem more like they're coming out of the blue because you don't see people lining up at that microphone. Thoughts on how the game plan for the meeting day changes with the chair and the role of the scrutineer, the secretary or parliamentarian? Any thoughts on that?
In our case, we are still going through that. We're one step at a time, but we'll be doing that as part of our run through. Our sense so far is that it's not that different, that the role of the chair is not that different, that we just have to figure out the technology of how the chair is going to see the questions and what the role of the secretary is going to be in helping the chair with those questions if needed. But that generally speaking, this is it's just a tweak. It's still, rather than coming to the microphone, they're coming to the chat room, and the same way that we would have our chair deal with questions, whether they're appropriate to the motion at hand or not, nothing actually changes that way. It's certainly new, but it's not entirely new.
One of the issues we often hear about in connection with virtual meetings is that issuers are using it to hide, avoid questions or avoid certain things from shareholders. So one of the things we often recommend is that you get potentially a third-party moderator to manage the questions, and then even if they are not answered at the meeting, that they are answered after and posted on the website so that there's transparency as to what's been asked, and that the issuer is providing responses to all of the questions that are appropriate. There could be inappropriate questions in there as well. And if that's the case, there should be an indication as to why a question cannot be answered, whether it's information that can't be shared or just a question that's not appropriate given the items that are being voted on at the meeting.
Nick, do you have anything to add to that?
No, like Chris, we're working through the logistics of all of that right now, and one of our other concerns is, you typically would have where is everyone going to be? Like, is the chair, the secretary, the CEO, the CFO all going to be in remote locations? So we're working through all the logistics right now.
I think a lot of us are making it up as we go along. We're about to find out how, we're doing our dress rehearsal tomorrow to see how it all goes. I guess that is another thought. We are not planning on having anybody in the same room. One thought might have been to, and at one point I had been willing to travel to wherever the meeting was to be with the directors and the secretary and the scrutineer. I think the decision's been made that we will do this entirely remotely and virtually. I suspect that this is a moving target for many companies who are moving to an AGM. I suspect that for most parts, Christopher, will you have anybody in a room together, or are you going to all be doing what we're doing today?
That's going to depend. It's almost too soon to say. Our meeting is in early May, so who knows what the world will look like at that point, and what we'll be able to do day by day.
Yeah, no, ours is in 2 days, so I know pretty much what we're dealing with, and that's why we're doing it this way. Nick, anything to add to that? So are you going to be all off doing it what we're doing today, and nobody in a room together, or wait and see?
I think we're at a wait and see right now. We're in a similar situation to Chris. As our meetings right now scheduled for mid-May. So yeah, it's day by day right now.
I'm scrolling. There's a lot of very, very good questions, and I think panelists are answering questions, or not panelists, attendees are answering questions for each other based on their expertise and sharing their knowledge and experience, which is great to see. I'm looking to see if we've got anything else to fill the last couple of minutes, but I think that we may be coming to the, oh, one new message. Let's see, we've got. So is there, I've got a question. Well, let's end on a positive note. Christopher, Chris started this discussion saying that, TELUS is in the business of providing telecommunications, and the idea that you gather your shareholders every year in a room to vote on things seems to be kind of quaint and old-fashioned. Do you think that this is going to possibly change the way annual meetings are held in the future?
I think what we're living through is going to change everything about how we meet in the future. We're all getting used to this technology, and we're all getting used to what this technology can provide. That's a really interesting time to be in. I think it's important to realize too that this technology can mean a lot more shareholders can attend. It's not just people in downtown Toronto or downtown Vancouver who can attend a meeting. Using technology, this is a way that more shareholders can attend our shareholder meetings. And I think that's a good thing.
That could actually really change shareholder meetings quite significantly, given that it could increase shareholder engagement significantly. I know that that may not work with every client. If you are a small member-based corporation, the annual meeting may be very important. It may coincide with other meetings. I know Farm Mutual Re has its annual meeting at the same time as other industry associations. So I think that there's a gathering of the community there that I think is very, very important to them culturally as a corporation. So again, I think that maybe something that depends on who the nature of the corporation. But I think for public issuers, this may be a very exciting change in terms of shareholder engagement. Anyone else have any final thoughts on that? I think we are getting very close to wrapping up. While you speak, I'm going to check these new messages.
From my opinion, I do think it's a turning point. We've certainly had many issuers express interest in virtual or hybrid meetings, but also express concern given Proxy advisors' reluctance to promote them or allow them, and just concern about the number of Canadian issuers who have actually moved forward with this type of meeting. So hopefully, we'll have great experiences holding these types of meetings. It does allow for more shareholders to attend, whether they're in further locations and can't come to downtown Toronto or Vancouver or wherever the meeting's being held. and also people who just don't have the ability to travel and are maybe, you know, would like to attend a meeting and just can't. So we're really hopeful that it will be a change and allow for more of this type of meeting, and that it will become more accepted.
Yeah, I agree. I think this is a great opportunity to provide more choice to all of our shareholders. And then this is probably something that we can look forward to in the future, and maybe GPC can sort of do a roundtable or a sort of a seminar on feedback from how did everybody do during their AGM season in 2020.
And I think, you know, for corporations that have found themselves in the position of either their bylaws are not flexible or their constating statute, the governing statute may pose problems. I think there is increasing flexibility in them, but this is also probably a good time for everyone to take a look at their bylaws and see how adaptable their bylaws are for the way things may be done in the future. I think, you know, bylaws are not something we often look at, and I think for many companies, they may be the biggest obstacle at this moment. It's like I said, it's I think you've all agreed, this is, you know, this could be a very good thing in terms of shareholder engagement is my view. I think we will, as you suggested, Nick, at the end of this, we should all probably reconvene and see what happened and how it went, and, you know, the experiences to take away from it. So I think we are in fact at the end of our hour, and I'm going to look at Lynn now to see if she's got anything further to add.
Thank you so much. Just would like to extend a huge thank you on behalf of GPC to our panel, Charlotte, Lara, Nick, and Chris. Thank you all so much for the work that you put into preparing for today. We appreciate how doing this electronically and in our natural habitats can be a bit challenging for everyone. Thank you to our participants for taking an active role in the chat area with your comments and questions. We will be putting this webcast recording on our online learning page on our website, which is gpcanada.org, as soon as it's downloaded, in case some of you would like to access it again, and we will capture the chat comments as well. And again, if you missed our webcast on Friday on risks, governance, and the role of the boards in COVID times, it is now available on that page as well. Now is a very important time for us to all come together and exchange best practices, and being a member of GPC will help you tackle the important issues that will help you throughout this time, and also help benchmark with your key colleagues and practitioners in governance. Some of our benefits include our online governance library, for instance, which offers precedents and templates, policies, tools, and useful links to find answers and helpful guidelines on governance matters. We have our education certification program. We have a request for assistance service that allows you to reach out to the community with key questions or concerns that our membership can weigh in on. So stay tuned for more GPC webcasts and events that will help you address important changes and questions in these challenging times. And thank you again to our panel and our participants today. And please reach out to us if you have any questions that GPC can help you with. And stay safe and healthy, everyone. Thanks so much.
Thank you.
Thank you.
Thanks, everyone.
Thanks.